Okay, well, thank y'all so much for joining us today here for the 2020 Women Texas Film Festival legal panel. And as you know, if you're attending, we got a very interesting topic today. And I just want to welcome you and encourage you to check out all the other films we have, short films, feature lengths, docs, Q&A, all that good stuff for free online this weekend. So please check it out. So real quick, my name is Brent Terman. I'm going to introduce our amazing panel today. First, we have Ruby Hunt. Ruby, you can wave real quick if you don't mind. Ruby has served as the DMA's Director of Human Resources since 2017. She now has a new role as the inaugural Chief Human Resource Officer, where she continues to direct the museum's human resources operations. She has nearly 15 years of experience in HR. That includes recruitment, training, benefit plan design, performance management, engagement, employee relations, 401k planning, succession planning, and diversity, equity, and inclusion policy implementation. Ruby has led the successful reengineering of the museum's HR strategy and processes and continues to evolve its practices. And her expertise in employee affairs has been successfully demonstrated very recently with the temporary closure due to COVID-19. Next, we have Gina Christ. She is a freelance film producer, and Gina's waving right there. She's from Little Rock, Arkansas, and for the last 6 years, she's freelanced in commercial, music, video, short, and feature film production. Before that, she was an in-house producer here for Dallas-based indie film company Dreamfly Productions and an LA-based production company 10 East, 10 West Productions, where she developed, casted, and produced non-scripted television pilots. In 2015, she won a Telly Award for producing work she did on Fame, a late-night style talk show for the Dallas Cowboys. And in 2017, she was a production manager and producer on the feature film 1985, which a lot of us obviously saw on the festival circuit, right? Starring Corey Michael Smith and others. And it premiered at South by Southwest and sold to Wolf Releasing. She also produces commercials, music videos for clients such as Uber, Old Spice, ACLU, Zach Brown Band, Doja Cat, Tyga. I saw the Tyga video on your website the other day. ASAP Ferg and others. She's a self-starter, a skilled multitasker, and she actually went to SMU, my alma mater, as well, and she currently resides in Los Angeles. Next, we have one of my colleagues, Elena Ackles. She is a labor and employment attorney at Bell Nunley Martin here in Dallas, Texas. She advises employers on how to minimize risk, protect their business, and navigate the multitude of state and federal laws governing the employer-employee relationship. She prepares employment agreements, confidentiality agreements, non-compete agreements, employee handbooks, and other policies to help employers mitigate their risk. She also prepares injury benefit plans for her clients. And it's really unique here in Texas. People can opt out of workers' comp, and she helps them with that. She's licensed in Texas and California, and since 2015, she's been selected by her peers as a super lawyer, Texas Rising Star. And she is just across the board, all kinds of employment-related litigation, as well as trade secret litigation and other matters, and then complex business disputes, arbitrations, and all of that. And I'm privileged to call her a colleague. I enjoy working with her on several cases. And she actually gave me a campus interview when I was trying to go to SMU undergrad for film school a long time ago. And so finally, my name is Brent Terman. I'm a board member for the Women Texas Film Festival, and I'm an attorney as well at Bell Nunley. I'm a trial attorney, but also an entertainment attorney. Due to my background, my first career was in film and television production, and I also get to handle transactional work with entertainment matters, whether it be creating, reviewing, revising agreements, negotiations, things of that nature. And so with that, real quick, I'm going to give you a roadmap for what today's panel is going to look like. First, we're going to give a legal background. It's going to be a mixed crowd we know out there. We have some attorneys, some non-attorneys. So we want to make sure that the attorneys get credit. And part of that is we're going to every now and then interject just a little bit of the ethical rules to make sure we get that very elusive ethics credit. Then we're going to talk about steps that HR departments can take. And this is not just in a film production, media production context. But from there, we're going to apply the law that we've learned and the HR tips we've learned and how we can use those in the production context. We're going to talk about issues that have arisen in the past and commonly arise, contractual provisions that are important, and also things to keep in mind to create a safer set, not just for some of the crew members, but for all of them. So first, Elena and I are going to discuss the legal background. And real quick, I just want to make sure we get our ethics credit in here. Obviously, sexual harassment, anything where gender is the basis of a decision, there are issues, and that's issue for attorneys as well. ABA Model Rule 8.4 talks about maintaining the integrity of the profession. And basically, it's misconduct, professional misconduct, for any attorney to engage in conduct that the attorney knows or reasonably should know is harassment or discrimination based on several bases, including sex, gender identity, sexual orientation, or a long list of others. So with that, Elena, can you please just start talking about just the nuts and bolts of what is sexual harassment in a legal sense?
Yeah, so thank you for having me here today. I'm thrilled to be here and visit with you guys. So, under the law, the law that applies to or governs sexual harassment is Title VII of the Civil Rights Act. And it outlaws any form of discrimination or harassment on the basis of sex. And there's really two types of sex harassment. One is called quid pro quo. It's Latin meaning this for that. So the most common sort of way I think that we think of that is like, if you have sex with me, I'll give you a promotion. If you don't have sex with me, I'm going to fire you, right? This for that. That is your typical sort of quid pro quo sexual harassment. The one that we see a little bit more often these days is known as hostile work environment harassment. And there are a couple of different pieces to hostile work environment harassment. You look at whether the number one, was the conduct sexual in nature? Was it directed at someone because of his or her sex? Was it unwelcome? Was the conduct directed at the individual? Was it unwelcome? Was it offensive? And there's an objective and a subjective piece to that. So was it actually offensive to the person receiving the conduct? And would a reasonable person also find it to be offensive? And then this is the fourth and maybe the prong that we get into the most when it comes to litigated matters, which is, was the conduct so severe or pervasive that it changed the terms and conditions of the person's employment? Okay. And this is a toughie because the standard under the law is actually pretty high in terms of what is going to rise to the level of severe or pervasive. There was a Texas Supreme Court case a few years ago relating to a University of Texas athletics coach. And I don't remember all of the facts in the case. I should have probably looked it up before today, but the gist of the allegations were that this woman was sexually harassed. She was subjected to unwelcome comments about her breasts. She was even, I think, touched inappropriately on several occasions. And this happened very frequently over a long period of time. And the Texas Supreme Court in that case actually found that the conduct was not severe or pervasive, and they found that there was no sexual harassment. I actually think the court probably got it wrong on that case, but it is kind of an example of that the bar can be relatively high in terms of what's going to constitute sexual harassment under the law. But I think what we want to focus on today, and something that Ruby's also going to talk about, is you don't want to find yourself in the middle of litigation arguing to a judge about whether something was severe or pervasive enough to be sexual harassment. So the goal today is for us to give everyone listening the tools and the guidance to prevent sexual harassment in the workplace. That is the goal. We don't want to be in a situation where some incident has happened where we're fighting in a courtroom about severe or pervasive. So the goal today is for us to arm you guys with a toolkit so that you can go back to your production company or your set or whatever it might be, maybe it's your law firm, to make sure that you have some strategies to prevent this type of conduct in the workplace or address it appropriately when these issues come up. And we will talk also about some defenses when they're legal defenses, when there is a situation that needs to be addressed, and ways to minimize liability. But I think I think Brent was going to kind of hand it over to Ruby to talk about, some of the procedures that companies can put in place on the preventative side, because we want to mitigate that risk and we want to prevent harassment in the first place.
Definitely. So Ruby has tremendous firsthand experience in the HR world. So Ruby, please give us some of your knowledge. Tell us about some things that you've done in your practice?
Well, thank you first off so much to Women Texas Film Festival for putting this panel together and for having us. Yeah, I think that that as Alana mentions is, ensuring that you have the steps in place from the beginning and really taking steps to prevent sexual harassment. So that includes training and setting the tone, right? So as a production company or organization or institution, it's tone at the top, right? So ensuring that the tone of the organization is addressing sexual harassment and the expectations around it right at the onset. So what can we do to support that tone? So implementing training, that's very important. So implementing a sexual harassment training for employees and for supervisors as well. So it's important that you have two separate trainings, one for your individual contributors, your employees, your maybe contractors that you work with, to ensure that that they're trained at the onset. But then at the same time, it's very important to also have training for supervisors. And the reason it's important for supervisors is because they need to know what to do in the event of an employee coming to them, or if they overhear something, their legal liability as supervisors who are acting on behalf of the company or organization. So it's very important to, one, implement a training program that in and of itself is allowing the institution to say, I train all of my employees, supervisors and employees on sexual harassment. Secondly, I think it's very important to also implement a sexual harassment policy and which includes a no retaliation clause and a notification process. So it's important to include that, after training and to ensure that individuals are aware of the steps that they can take when if they're notifying a supervisor or an individual within the institution. And we'll talk a little bit more about, implementing a step process, but tone at the top is very important. Training is important, a process, a no retaliation clause, and have the employees or contractors, your freelancers sign off on that from the onset. So you have paperwork on your end and that states that you've done your due diligence in training your staff.
And definitely as attorneys, we love when that paperwork is there, right? Because that's going to help us if and when anything happens in the future. And Ruby, we talked about this on our prep call, but what was interesting to a lot of people is, supervisor's not just the head honcho, not just the person at the top, right? Who does supervisor include?
Supervisor can really include any individual that has a level of authority. So it can be, an assistant director or, producer, an assistant supervisor, even that top level of that bottom level of supervision all the way to the top. So we're arming those individuals with power to supervise employees. So we need to ensure that they're properly trained. And it also, an example of this is, in several different situations that I've come across, we've had an individual supervisor who is your frontline supervisor, maybe an employee mentions something to them, shares with them a small story of maybe an incident that occurred with another employee. And I've come across situations where the supervisor thought that they were hearing a vent session, and it was more of that friend approach. And so they did nothing, and they didn't notify HR or their direct supervisor. So ensuring that your supervisor has that hat on and knows that yes, you can be friends with your employees, but you always have that hat on of representing the organization. And when you hear something that could be classified as sexual harassment discrimination, that it is reported, and they know, okay, like they know those warning signs, and they pick up on those and they take the appropriate action.
So what I'm hearing are important things from your perspective are making sure the training up front to everyone who could be considered a supervisor, just so they have that kind of top of mind as they go forward with their job, whether it be a short-term job, like, you work on a set, or a more long-term, at will job. And so that's very important. We're definitely going to talk a little bit later. I'd love to talk more with you about some of the reporting options you have for employees, and we will definitely get back to that. But first, I want to come back to Elena, and let's discuss some ways to limit liability from the employer's perspective. And you can obviously, everyone here who's in film, be thinking about this from, the employer could be a production company. It could be something of that nature, even if it's just for this shoot. Think about how it could apply in your context, and we're definitely going to talk more about that.
Yeah, absolutely. And I know we'll talk about it again later, but where I see issues coming up most frequently under the heading of what Ruby was just mentioning are sort of your lower level managers. So really zero in on those people and make sure that they understand that they speak for the company. Like the producer is usually going to understand that they are the production company. It's your sort of lower level managers that really struggle with that concept. And those are the people that might get you into hot water later if someone has come and done one of these vent sessions to them and they just said, well, she was coming to me as a friend. We're best friends. So I didn't think I needed to do anything. And I hear that a lot, and it comes up in my litigated cases quite a bit. And it's a challenge when that issue comes up. But let's talk now a little bit about ways to limit liability just from a legal perspective. And this will also go to some of the strategies that Ruby mentioned. So there's a defense to liability for sexual harassment. So even if there was sexual harassment, there's a defense if it's called the Farragher-Ellerth defense. You can Google it if you want. But it is essentially that if the employer took certain steps to prevent and remedy sexual harassment, then they're not liable under the law. And so there are a few steps to take under the Farragher-Ellerth defense. One is that the employer has to show they took steps to prevent harassment. So what does that look like? That looks like having a policy in place, that an anti-harassment policy. It means having training in place about what is sexual harassment and how to prevent it. And then it also means having a procedure in place through which an employee can complain if they feel like they were the victim of sexual harassment. And that's really important. We want to make sure that we communicate those procedures to our employees so they know what to do and what avenues they have to complain if they experience harassment. Because if we fast forward in litigation later, if the employer has established those avenues for communicating a complaint and the employee never exhausted those avenues or never utilized those avenues to complain internally and give the employer a chance to remedy the situation, then it's a defense to liability. So that one's really important. The next prong, the second prong, is that once a complaint is made, the employer has to do a prompt and thorough investigation. So what that looks like is gathering any relevant documentation surrounding the allegations, interviewing possible witnesses and people with relevant knowledge, and then ultimately looking at everything and deciding whether you believe harassment occurred and whether you believe a violation of your policies occurred. And then the third is, based on that investigation, taking appropriate action. So in the case where you found that there maybe was harassment, or there was maybe not harassment, but a violation of your policies, that could mean disciplining the alleged harasser. That could mean firing the alleged harasser. So there's a gambit there in terms of severity, but the employer has to show that they took appropriate remedial measures to address whatever the results of their investigation were. I'm trying to think of, so that's really the Farragher-Ellerth defense. And you want to just make sure from a risk perspective that all of those steps are documented along the way. so that if you do end up in court someday, someone like me is going to be able to have that to enter into evidence, and you'll be set up for success if you follow those steps.
And one thing I'd like to hit on, just so we make sure we get our ethics credit, one thing that Elena said, which is true, is a lot of times it's the lower level supervisors, lower level management, but attorneys can find themselves in an interesting situation when it is an executive, a CEO, something like that, and maybe they're the one who hired your law firm. You need to remember, under the ethical rules, who you represent, who is your engagement letter with. A lot of times you're going to represent the company, the entity, not that individual. So you have to make sure you owe your duties to the company, not that individual. That's an ABA Model Rule 1.13, as well as Texas Disciplinary Rule of Professional Conduct Rule 1.12. And comment number 1 to Rule 1.12 really just, I'm not going to bore everyone here, but it really makes it crystal clear who you owe your duties to. And so next is the production context. So like I said, my first career was in production, and it's fun explaining to people who have never been involved in production what that world is like. So Gina, if you could please, for anyone in the audience who has never worked in production or minimal work production, just tell them what that lifestyle is like.
Yeah, for sure. So when Ruby was talking about just now knowing who is in charge, that's kind of where the tricky part comes in, because you work with who you're friends with, and you're friends with who you work with oftentimes in production, and especially in the freelance world. And for me, as a freelance producer, I'm moving from job to job, gig to gig, but I'm always an employee of the production company. And as you were saying, of knowing who that direct supervisor is, that becomes me on many sets. That becomes the people that are directly working with me or directly below me. And so it does get tricky because it's hard to set the tone and then have a one-day job and then go to the next. So for me, I've been reflecting a lot during this quarantine time, because we have been coming together as producers to come up with a very clear-cut protocol for the way that we were going to do things post-COVID. So I've been thinking a lot about, okay, I mean, this kind of in comparison to thinking about sexual harassment, it shouldn't be much different. So we have a very clean-cut plan going into productions now of, we're gearing up for this production, everybody gets tested, this is what happens if somebody gets sick, et cetera, et cetera. But I was thinking about it and I was like, I haven't sat down and had this conversation on every set that I go on. And albeit I'm going from job to job all the time, but it should be just as important. And it should be a conversation that comes up. It doesn't have to be a huge conversation, but if it's a one-day gig, it's like, put the steps in place, put something in your crew deal memo, make a small announcement at a safety meeting, things like that, that can at least show everyone up front that it's something that we're always thinking about, that we're not okay with, that is a zero tolerance policy, and really, really just be upfront about that stuff. So yeah, production world, it's very different because you are going from gig to gig, and as a producer, people do end up knowing you because you're the person that's hiring people on. They end up associating you and your work with what kind of set you run. So you do always want to bring that stuff with you. And that's something that, for me, I'm going to bring forward on every set now that we've really, really addressed it and come up with solutions for it.
And that's great when the producers do that, because, I mean, for anyone who's worked their way up the ranks, you're a PA, an AC, whatever, you're in a vulnerable position. You don't have job security, right? Unless you're with a big studio working on a series or something. And so it's a vulnerable position, and it's important to have someone at the supervisor level advocating for everyone else there. And we can kind of just open up too and talk about, I mean, what are some, we don't need to name names. What are some kind of things that you've seen on set? I mean, I'll start saying, I worked in LA for a while, heard a lot of uncomfortable comments from people who worked in, I was not in this industry, just to be clear, but a lot of people worked in the industry that gets a lot of First Amendment protection out there. They had a different sense of humor and saying things that you would not want to hear in the workplace. But what are some kind of things that you've seen in your experience on set?
So I've seen a lot, but I will say that I would say the most common thing that I deal with and that other producers deal with on smaller shoots and things like that are the comments, inappropriate comments. I think it's taken in one of two directions. Oftentimes it's gendered comments, and then other times it's sexually charged comments. And those are uncomfortable. They're uncomfortable to deal with. Like you were saying, someone who's new on that set who hasn't worked with that team of people before ends up being an outsider and ends up being the butt of the joke or not understanding the joke or things like that. And that's not okay. And that's not fun for anyone. So that's a big common one that happens pretty often. And that's something that I like to address immediately. So I do like to make sure that people know as soon as you've heard a comment like that, that's something that if you don't feel comfortable addressing, you can talk to me and I'll address it immediately, because that makes for an uncomfortable working environment.
Well, just like Ruby said earlier, you want to set the tone from the beginning. If that's something that's allowed and permissible on your set, I mean, you're encouraging, whether you know it or not, you could be encouraging others to have that same outlook and even amplify some of the actions. And so I'm gonna go back real quick. We had a question in the crowd about, for smaller production companies and owner-operators who hire freelancers but are not large enough to have an HR department, are there resources for providing that type of training to freelancers or contractors? I was going to open up the panels. You want to have, first off, I want to talk about reporting, because that's something important as well, as Elena talked about, for just making sure you're doing what you can to allow people to report. A lot of times we have clients who use third-party services to where someone can feel safe reporting a complaint, and it's not going to, get to someone who may take it out on them, anything like that, retaliate, anything like that, which you shouldn't do. But, and Ruby on our pre-call talked about setting up a website for anonymous reporting, and this can be done on a small scale for Will. You don't have to have a big budget for this, but it's either an email address or website. Ruby, can you please just elaborate a little bit on that?
Yeah, so oftentimes, companies or small firms that don't have large budgets, an easy anonymous page on your website that allows for just a comment box for employees or contractors or freelancers to report something and allow those messages to go to one or two of your top individuals within your production company or your organization. But then it's also equally important that what is the action being taken once you receive those complaints. And so ensuring that any complaint that you receive either anonymously or in person is acted upon. And we discussed earlier, it's important to close that circle, close that loop. So if you receive a complaint, you'll receive complaints, varying severities of complaints, and it could involve just a conversation. It could involve, interviewing witnesses, pulling video footage, pulling voicemail messages, emails, any of those sorts of things. Or it could just be, a conversation. So ensuring that when you do receive something that you act, so either taking that investigatory process completely through the end, and then a follow-up action too. So ensuring that you follow up at the end with the individual that submitted the complaint to ensure that you close that feedback circle. So if it's anonymous, it's a little more difficult, right? Because you don't have someone that you can call to discuss further and really try to investigate the process. But you can, again, if those are anonymous, you can reinforce the policy, have an all staff meeting to, again, go through what the no retaliation, the no space for a hostile work environment, all of those things you can reiterate again should something come to you anonymously.
Perfect. And I think you hit on too, one thing I know is really important to Ruby is transparency to those who are reporting and making sure they know what the next steps are. And we're going to talk about a step process a little bit later too. I'm getting ahead of myself. But one thing I want to come back to Elena and talk about, just hitting back one point on that question. Are there any resources, or if not, clear resources, good advice just for smaller companies who are going to be training freelancers and contractors?
Yeah, so there's some great resources. So one, you can handle it in-house, right, to establish some of these policies and procedures and do the training, and set up sort of the anonymous inbox on the website, which is a really easy, free, if not free, relatively inexpensive way to set up a complaint procedure. There are third-party companies, vendors that do this, and they're actually pretty they run the gambit, right? I mean, you can have your sort of Cadillac version of the vendor that does all they outsource everything and all the HR functions. Obviously, that's a little bit more expensive, but there are also vendors. A friend of mine actually runs one called WorkShield, but there's a ton like that, and they usually charge by employee head count. So whatever that is, like $2 a month per employee or something like that. So if you're a relatively small business, the cost isn't that tremendous. And what they do is they set up this third-party place where employees can go to complain. And then if they receive a complaint, they will actually do the investigation for you as well and come back to you with their findings. So there are resources. And the main thing is making sure that you also communicate those resources and avenues for help to the workers. So going back to something that Gina touched on earlier, and again, I know this is a common theme that we're talking about today, but setting the tone at the outset, right? So when you're having those meetings to talk about whatever it is, whether it's COVID safety or whatever, make sure that you spend a few minutes talking about what will or will not be tolerated on set, the avenues that an employee can go to if they feel like they've experienced harassment or discrimination. And that's where you want to make sure that you've communicated to them whatever it is, the inbox on your website, the third-party vendor, the producer, an open door policy is what that's called, when someone can go to any member of management. And so you want to make sure that those avenues are communicated. And just along the lines of setting the tone, we got an audience question asking about, any suggestions for addressing things in the moment. And I think this came up when we were talking about, the inappropriate jokes, which in talking with Gina and Brent, it sounds like that's one of the big ones, right? In this industry is sort of the inappropriate jokes or comments. And Ruby may have some other suggestions, but I would make sure that anyone on the management team knows that your expectation is to address that in the moment. And similarly, if someone complains about it, it needs to be addressed immediately. And while a stray remark, that's what we call under the law, a stray remark, okay, is not going to rise to the level of sexual harassment, it's all about setting the tone and making sure that you're promoting a culture that doesn't tolerate that kind of conduct, because it's sort of like a snowball. If you allow the inappropriate jokes and you allow the offensive commentary, well, what's the next thing that's going to be allowed? Is it going to be a sexual assault? So that when you have that kind of culture, and we saw that, right, in part of the Me Too movement, I think the quote about Matt Lauer was the person went to HR and complained about Matt Lauer, and the HR representative said something like, are you saying you want me to investigate Matt Lauer? Yeah, right. And when it came to Charlie Rose, I think the woman said, I didn't think I could complain because it was Charlie's production company. I didn't feel like my opinion mattered or my say mattered. And so we want to set the tone at the outset that we do care and we don't tolerate that. And it could be as simple as something when someone makes the comment, you just say, hey, that kind of joke is not consistent with the work culture that we're trying to promote here at Acme Productions. And so I'm going to ask that you not say those kinds of things anymore. And if it continues to be an issue, we're going to have a more formal, serious discussion about it. And so just addressing it in the moment like that, it doesn't have to be some great big sit down. It can just be, hey, that's not consistent with the work culture we're trying to promote here. So I'm going to ask that you not say those kinds of things anymore. And your management team should be ready with a canned response like that, so they're not caught off guard. You want to arm them with a little script of what they can say to address those things in the moment. Hopefully that helps.
That's very helpful. And Elena, a lot of that's talking about the management team. And so there's a question earlier about what we can do to train new supervisors. And I'm just going to kind of modify that question. What about people who are lower down the totem pole? What can we do to help train them, other than making it very clear, like we talked about earlier, you are seen as Acme production company, right? Like when you are wearing this hat and in that role, you represent the company. Other than that, do you have any thoughts on what we can tell lower level supervisors?
I think you just want to make sure, and again, we say training, it can be a formal training. I go into companies all the time and do management training. So if you have the resources and you want to hire an outside party to come in and train your management team, that is a easily accessible resource. You can also do it on a much smaller scale by sitting down with your management team, and include this in the onboarding as well. When you bring someone new on, you want to highlight for them, you're going to go through your big stack of papers, right? But you want to highlight for them what your policies are on harassment. You want them to know that you take it seriously, and that your expectation of them, if they receive a complaint, is that they will escalate it to you or whoever it is that's going to handle that stuff. You want to kind of help them have the tools to issue spot when something rises to the level of a workplace complaint, so they know how to identify that. And you want to also make sure that you arm them with the tools and maybe the canned script, and make sure they know your expectation of addressing inappropriate language or conduct in the moment and how they should go about addressing that. And that should be done at the outset with the onboarding process. Or if you have an existing team, in just a management team meeting. And it doesn't have to be anything elaborate, but it's just really important to set the tone at the outset so everyone knows the expectations going in.
And while we're talking about, actions to take if and when terrible things like this happen, Ruby, you talked about the step process before with me. Can you explain what that looks like to you?
Sure. So the step process, and you'll want to build this into your sexual harassment policy. So when you have a policy, you'll include quid pro quo, this for that, hostile work environment, examples of that, the no retaliation clause, and then the reporting procedures. So normally what I recommend is a 3-prong approach. Is first, allow the employee to empower your employees to allow them to have the conversation and feel empowered enough to have the conversation with the harasser, whether it's a comment, arm them with scripts like, that comment was inappropriate. I don't appreciate that. Do not say those sorts of things again. If they don't feel comfortable doing that, they can definitely report it to a next level supervisor, whether that is, that first level or above. And then that's recommended. And then lastly, the next step would be reporting it to the very top, or HR if you have an HR department. So ensuring that there is a step process. There's no requirement to follow that step. You can choose whichever step feels comfortable for the employee at that moment, but recommending various avenues to which they can report that harassment, including the anonymous either phone, voicemail phone number, or the website. So just allowing them to know, like, these are the steps and the avenues on how to report harassment. And I know one of our the audience questions was, what tools are available for cast, and crew? And, there's several organizations without, large budgets or HR departments. And there's several free resources there's YouTube videos that are out there on sexual harassment training. There's free sexualharassmenttraining.com that offers free sexual harassment training. You could even put a quick slideshow presentation with voiceover and turn it into a video and share that out as a link to onboarding, right? As Elena mentions, it's have them sign off on the sexual harassment policy and procedures. You must be required to watch this video before starting work. And then the sign-off sheet, I have signed the policy, I have watched this video, and I think, an extra step would be like, I commit to supporting a hostile-free work environment, free from sexual harassment. So another neat thing that you could add in is developing core values, and having that part of the core values of the production company as well.
And one thing that I think is very helpful there is talking about there's various avenues to report through, because obviously we can envision a situation where if there's one person to report to, and that's the person that you're reporting about, there's an obvious issue. So definitely giving flexibility and still, talking the talk, but also walking the walk, doing what you say what you're going to do is huge. We're going to DC for just a minute and talk about some contractual provisions here. And so let's be real. This has been happening, for a long time. This is not a new thing, but only recently has it become a big thing as far as the mainstream is concerned. And so with that, one thing that has been huge that people have been relying on is the morals clause. Definitely, if you're working with contracts, you want to make that very broad enough to protect your client, assuming your client's the production company and not represent the talent, right? And you want to make sure, like I said, you need to talk, but also walk the walk. If you say you have a zero tolerance policy, and then it's clear that you have knowledge of A, B, and C and don't do anything about it, that's something that could become an issue later, again, when you're at trial with someone like me or Elena. And also we talked about anti-retaliation clauses. And a lot of you, I know a lot of people, including myself before I was an attorney, I'm just tallying on myself now, didn't read every line of the deal memo, right? And so there's stuff in the deal memos about this. Gina, have you seen anything about this? Just taking a look back at some of your more recent contracts you've either signed or had other people sign?
Yeah, so in my deal memo that I take to productions, I have a sexual harassment and anti-harassment policy in there. It's a short clause, and it addresses everything. I can read it for you if you would like.
Yes, please, go for it.
Yeah, it just says harassment policy. This production is committed to providing a safe environment for all employees, talent, participants, and associates, free from discrimination on any ground and from harassment at work, including sexual harassment. The production will operate a zero tolerance policy for any form of sexual harassment in the workplace and treat all incidents seriously. Examples of conduct or behavior constituting sexual harassment include, but are not limited to, sexual comments, stories, jokes, sexual advances, repeated and unwanted social invitations for dates or intimacy, insults based on the sex of a worker, unwelcome physical contact, physical violence, the use of job-related threats or rewards to solicit sexual favors, display of sexually explicit material, sexually suggestive gestures, whistling, or leering. Any person found to have sexually harassed another will face immediate dismissal from the project. All complaints of sexual harassment will be treated with respect and in confidence, and no one will be victimized for making such a complaint. So that's pretty standard, and obviously it can be edited or expanded upon, but that's in like a pretty simple deal memo that goes around with me from set to set.
And I know you can easily get tired head reading through like provisions like that, but it's very important. And I love how broad that is. And you just heard all the examples of things that are covered by that. Definitely. Gina, we talked before this, one thing interesting, you had a big kind of a moment where you realized how this has been ignored. I know we knew this, but there's a specific moment you talked about. You saw there was a COVID specific person on set for COVID. And that alone, what was your thought when you saw that?
Yeah, so I touched on it earlier, but I feel like I had a lot of time to think and a lot of time to like get documents together and get really organized for productions that were happening post-COVID or during COVID era. So I was thinking about why there wasn't already a compliance officer on set for sexual harassment, or at least a designated crew member that's pretty clear up front from the beginning, the person or persons that you should go to report this kind of stuff. And then I did see a question asking about what position on set would be in charge of checking complaints. And I feel like that could be producers and production managers, because those are the people that are typically hiring on the rest of the crew. But like you said, I do think it's important to introduce those people as those compliance officers up front so that people know that those are specific people that are going to keep your complaint in confidence and that there are multiple people you can go to, because if one of those people are the person you have an issue with, then you want to feel comfortable going to somebody else. And I know I'm kind of going all over the place here, but something that I thought about earlier was that sometimes productions are long-term. They're like months at a time, and sometimes they're a couple weeks at a time. But oftentimes there isn't time to put out a video, require everybody to watch it because you crew up for a shoot that's happening in 48 hours. So for things like that, I feel like it's important to remember that there are little things, little steps you can take, because I was doing a few shoots that were 48-hour turnaround during this COVID era, and we still got our stuff together, and we still made sure that everyone was checking in and everyone was getting their temperature checked and getting the symptoms checked and getting tested before coming to set. So I feel like even if you don't have time to watch a video or do things like that, you can definitely have people come and sign this clause on their way in with the NDA that they're already going to sign. So there are little things that already happen on set, even on short-term productions. And there are easier ways that are small and quick to do, just to address the fact that we're thinking about this and you should feel comfortable reporting it.
And I think you said earlier, but you kind of dealt with some of this recently. Has this issue that we're talking about today, has this been brought up in the safety meeting?
That is something that happened on a set of mine that first AD just brought it up. They asked me about it. Do you guys have a sexual harassment policy that you want me to go over? And it was a 2-week shoot. And I thought, wow, this is so great. Like, why not have this in the safety meeting? So I feel like you have a safety meeting on every set going forward. So even if it's just a sentence, just like you're going over, if you have any COVID questions or COVID complaints, this is who you talk to. I think it's definitely something that needs to be brought up in safety meetings as well.
And that's a good point. It's not a 30-minute training before every day you shoot, right? It's just something that's addressed, part of your culture for whatever your production is on set. Someone else asked, if you're contracted by the production company, is the burden on you as an individual to ask the production company to discuss the harassment policy? Of course not. That is not a burden on you. I mean, the production company should be wanting to do that on their own. But definitely it's interesting. I mean, when production companies do not have anything like that, it can create at times, just a little question marks, right? Because it hasn't been addressed and people are allowed to infer anything else.
And so piggyback on that, Brent, just, piggybacking on what you and Gina were just talking about, I think the more that, the people on this webinar right now, and the people that are out there and want to make a difference, the more that we can incorporate sexual harassment prevention into our everyday fabric of how we do business and run our operations, the quicker we are going to be able to eradicate sexual harassment in the workplace. And so, if you think of yourself as sort of a mini ambassador, there are things, if you're on the employer side, certainly that you can do. We've been talking about that, incorporating it into your safety meeting and things like that. But in response to the question about, hey, is it incumbent on me to ask the production company what their harassment policy is? It's not incumbent on you. There's no rule that you have to do that. But if you highlight that in a safety meeting or in your negotiations up front as something that's important to you, the more people that do that, the more the production companies are going to respond and recognize that this is an important issue to the people that they are bringing in to the set, and the more incentivized they're going to be to address it and put those procedures in place. So there's no law saying you have to raise it, but just if you think of yourself as sort of a mini ambassador for wanting to eradicate sexual harassment in the workplace, the more that we can raise these issues and make them just as important as stopping the spread of COVID, I think the faster we'll be able to eradicate sexual harassment in the workplace too.
Exactly. And Elena, what you're saying right now really just reminded me of something that's important, and a lot of people it's important to at our firm, though, not only is the shine theory. You're talking about there's power in numbers, and I know a lot of you may be familiar with it, but if Elena, if you could just kind of give a broad overview of what the shine theory is.
Yeah, so the shine theory was created by a group of women during the Obama administration. And the gist of it was that, they would be sitting in these meetings. They were Obama staffers, and they felt like some of the women felt like during the meetings, they would be sort of shut down by other men in the meeting, or, they would say something and no one would say anything, but then a man would say sort of the same thing. And everyone would be like, great job, John, really great idea. It's sort of this, they call it bropriation. Some of you may be familiar with that word. So the women got together and decided that they were going to implement what they call the shine theory. So if we're sitting in a meeting and Ruby said something and had a great idea, before anyone else could interrupt her or jump in or steal her idea, I would jump in and say, Ruby, that is an excellent idea. Thank you for raising that important issue. And I would shine the light on Ruby or Gina or whatever. And so, it occurs to me that this isn't a gender issue necessarily, but the collective we that care about these issues can shine a light on best practices and make sure that the powers that be, so to speak, know that these are important issues that are important to the people coming on set every day. And that may be a really good way to make a difference.
And I got to make sure we get a little bit of more law in here. So I had one thing I wanted to, either Ruby or Elena, whoever would like to talk about this, please explain to the audience what a love contract is.
I'll take this one. So a love contract is a consensual relationship agreement. So as Gina mentioned, you're working on set, you are friends with those individuals, maybe a couple of your, freelancers start dating and they start working on set. To further safeguard your production company and ensure that you're, doing everything you can to create an environment free from sexual harassment, you could implement a love contract, a consensual relationship agreement. And that's basically stating you give this contract to both individuals and they state that they are in this relationship together. It's consensual. You place it in their files with their NDAs and everything else. And it's on file. And so that's something else that you can take to safeguard the organization.
Definitely. So it's I imagine it's an interesting contract to have to sign, but there are obvious reasons why the employer would want to have that contract on file. Elena, we had another question come through. Once someone reports sexual harassment, what are the actions that the higher ups are expected to follow? At what point does it become a legal case?
Yeah, great question. So this goes back to some of what Ruby was talking about, the various steps. So once a complaint is filed, the employer should conduct an internal investigation. And what that means is doing some of the things that Ruby mentioned, pulling emails, text messages, voicemails, whatever that is. So gathering the documentation, we want to gather the relevant evidence, right? So that could be in the form of pulling together those different messages or documents, and then also talking with the relevant people. Something that comes up quite a bit is confidentiality in these investigations. So, we want to make sure, the process is confidential, but that doesn't mean it's completely confidential. The information is shared on a need-to-know basis. And the reason it's shared on a need-to-know basis is because the employer has to investigate it. So I have to talk to the alleged harasser about what happened on August 1st on set or whatever it might be. I might have to talk about some people that were eyewitnesses to the incident. But it will only be shared on a need-to-know basis, but we just have to make sure that we're not suggesting that the information won't be shared with anyone, just because then we wouldn't be able to investigate. So that comes up a lot as a question. I think that Ruby and I probably get frequently, well, who can we share it with? It can't be shared with anyone that doesn't absolutely need to know the information. So anyways, you do the investigation, you talk with the relevant people, you pull all that together and decide whether you think there was sexual harassment or a violation of your company policy. And then you take appropriate action based on that. So that might be just talking with the individuals and explaining that, based on everything, all the information you've collected, it appears, you know, that this was a misunderstanding or something like that, or based on the information that you gathered, it does appear that there was sexual harassment and a violation of company policy. And based on that, the alleged harasser, or now the confirmed harasser, maybe after your investigation, is going to be fired or suspended or disciplined or whatever the case may be. You know, this can be a challenge, I think, in your world when you are doing a one-day shoot or something like that, instead of having these sort of long-term employees. But I still think it's important to address the situation. So even if you were going to the harasser after a one-day shoot, you know, it might be something like, hey, listen, this is this conduct, we did an investigation, here's what we found. This conduct is not tolerated by this production company. It's inconsistent with our policies and our core values. And even though that shoot is over, we want you to know that if you ever come back to work for this production company again, you will be expected to comply with our core values and our policies and procedures. Or maybe you decide that you're not going to ever hire that person again if the conduct was so severe. So those would be the steps in terms of, and then it's sort of case closed. You do your internal investigation, you take appropriate action, and you just document that in the file. When it becomes a legal case is when either before, during, or after that process, you get what's called a demand letter from a lawyer. The victim files an EEOC charge with the Equal Employment Opportunity Commission that you'll be asked to respond to, or they may file a lawsuit either in court or in arbitration. And that at that point, you'd want to get a lawyer involved to defend your rights and respond to the allegations.
Okay, well, we covered a lot today. We are getting close to the end of our hour, so I definitely want to make sure if you have any questions, please let us know. And then I will come back to you, Gina, in just 1 minute with that question. But I want to make sure first to make sure our lawyers are able to get credit. Get your pens ready. I'm going to give you the course number so you can self-report. The course number is 174093. 077. Write that down, Elena. Make sure you get your credit. 174093-077. And if you have any issues with self-report or anything like that, please let us know. I'm going to give you the email address for someone to email. Her name is Sherry Story. Her email is sstory, STORY, at bellnunnally.com. And that's a law firm that Elena and I work with. sstory at bellnunnally.com. Also, for all of y'all, we're not done yet, but I just wanted to tell you, if you would like to donate on Eventbrite on Facebook, we would obviously encourage that. If you're attending this, if you've seen any films, you know what the Women Texas Film Festival is about, and we would appreciate your support. And so, Gina, if you could talk about this last question, can you speak to examples of appropriate action being taken on set, especially regarding cast, to the extent that you have any experience with that?
Yeah. So I only have one experience regarding cast, which was on a 2-week narrative shoot. And it wasn't one of our leads, but it was a supporting role. So they did have many speaking lines. And it was an incident where it was inappropriate physical contact happening. So it was definitely directly in line with zero tolerance policy. So on that set, it was in day 3 or 4 of 2 weeks of shooting. And we immediately removed that person from the shoot and rewrote them out of their part, which was luckily we were able to do. I understand that oftentimes if it's your lead role or your star, that's not immediately the first option. And that's when like the step process needs to come in place. But in that case, we rewrote and removed that person from set. And we were immediately very transparent with the cast and crew on what had happened. We gathered everybody for a safety meeting that following morning and explained that this person broke our sexual harassment policy and was removed from set, and reminded everybody of what the policy was. And luckily on that shoot, everybody had signed sexual harassment policy waivers and things like that going into it, because it was more of a long-term thing. So that's how that was handled. And with smaller comments and things like that, that happens more often than not. And I usually typically err on the side of addressing it immediately, on a shoot just a few weeks ago, we had some inappropriate comments. It was addressed immediately, and I took it to that person's direct supervisor as well, so that they knew what was going on. And then, yeah, I think that creating a step process up front is what's going to kind of save you there, so that you're not going into things blind and that you're prepared for whatever comes your way. One thing I was going to add from earlier is that when you're a producer going from project to project, you typically are handed a production handbook or a guidebook from that production company that you're working for. And if there's not something explicitly explaining sexual harassment in there, that's a great time to bring it up and ask the production company, what's your policy on this, just so that I'm aware, and get that in writing from them, so that you've got something to go by if anything happens.
Perfect. Well, I want to thank everyone for attending, and I want to thank our amazing panel, Ruby, Gina, Elena. Thank y'all very much for joining us today. We respect your time. I know it's 1 o'clock and we are done. Again, I'm reading for the attorneys the number one more time, 174-093-077. And with that, whether you're an attorney, whether you're not, check out our content at Women of Texas Film Festival. Again, shorts, features, docs, Q&As, everything for free. Bring your own popcorn from the comfort of your home. You can enjoy the festival this year. Thank y'all very much.